The Honorable First Member for Vaca-Floreal.
B883.
Mr. Deputy Speaker, sir, I am informed by the District Council of Black River that Moselma Baobab Limited submitted a total of 7 applications for the building and land use permit in respect of a proposed residential development at Black River Road, Gros Caillou. Out of the 7 applications, 6 were either set aside or rejected before any approval was granted. 4 applications were set aside due to the failure of the applicant to provide the information, clarification, and supporting documents requested by the Council. 1 application was rejected owing to the absence of mandatory clearance from relevant authorities, including Central Electricity Board, the Land Drainage Authority, and La Femme Adenta Water User Association. Another application submitted for a development comprising 35 residential units was set aside following advice from the Ministry of Environment, Solid Waste Management and Climate Change that the proposed development constituted a scheduled undertaking requiring a preliminary environmental report clearance, that is a PER. Mr. Deputy Speaker, sir, a revised application was subsequently submitted on 1st September 2025 for the construction of 25 residential units. I am informed that the revised proposal differed materially from the earlier submission in terms of its scale and layout and was assessed as a new application on their own merits. The application was referred to the relevant technical authorities and favorable recommendations were received from the Wastewater Authority, the Land Drainage Authority, and the Water Resources Unit. At the time the application was assessed, the Council had not received any determination from the Ministry of Environment indicating that the revised development of 25 residential units constituted a scheduled undertaking requiring a PER clearance. Mr. Deputy Speaker, sir, the application was thereafter considered by the Permit and Business Monitoring Committee, that is the PBMC, which is a collective decision-making body comprising elected members and officers of the Council. Following consideration of the application and recommendation received from the relevant authorities, approval was granted at the committee meeting held on 6 October 2025, and the building and land use permit was subsequently issued in accordance with the applicable statutory procedures. I am further informed that it was only on 27 January 2026, that is more than 3 months after the permit had been approved and issued, the Ministry of Environment, Solid Waste Management and Climate Change informed the Council that the development of 25 residential units should be treated as a scheduled undertaking requiring a preliminary environmental report clearance. Upon receipt of that communication, the Council acted immediately. The promoter was informed that the requirement and at its meeting of 6 February 2026, the Permit and Business Monitoring Committee resolved that an additional condition be incorporated into the permits requiring the promoter to obtain the necessary preliminary environmental report approval prior to the commencement of any development works on site. The promoter was accordingly advised that no works could proceed unless and until the required environmental approval had first been obtained. Mr. Deputy Speaker, sir, with regard to the allegation of conflict of interest, I am informed that the matter was raised for the first time by way of a letter dated 29 April 2026, more than 6 months after the Permits and Business Monitoring Committee, that is the PBMC, had considered and approved the application. I am further informed that the application was considered by the PBMC in the presence of several members, including Mr. V.B. in his capacity as District Councillor and member of that objection, reservation and concern being raised by any member, including V.B., in relation to any alleged conflict of interest during the consideration of the application. The allegation subsequently made does not constitute a finding of conflict of interest. It remains an allegation which is presently the subject of investigation by the competent authorities. It is not for the District Council or my ministry to speculate on or determine the merits of that allegation. The responsibility falls within the remit of the competent investigative authorities. Mr. Deputy Speaker, sir, I wish to inform the House that concurrently an inquiry has already been initiated at the level of my ministry regarding the issuance of the BLUP, while the allegation concerning possible conflict of interest have been referred to the Financial Crime Commission and other relevant authorities for investigation. At this stage, neither the District Council nor my ministry has established the existence of any possible conflict of interest. In the absence of any such finding and in view of the ongoing inquiry and investigations, it would be inappropriate and premature to draw a conclusion or prejudge their outcome. Any decision or action that may be required will be considered once the inquiries and investigations have been concluded. Thank you.
Yes.
Je vous remercie. Je souhaiterais déposer d'abord la lettre de signalement authentifiée. L'honorable ministre peut-il informer la Chambre si le clearance du ministère de l'Environnement n'aurait pas en principe dû avoir été obtenu avant que soit délivré le permis de construction, le BLUP?
For above 30 units of residential permit, it needs a PER. Under 30 units, we don't need a PER. But it depends on the minister. It can ask for a PER even of under 25, like as is the case. It depends on the minister to decide.
Yes, Honorable.
L'honorable ministre peut-il indiquer à la Chambre s'il y a eu également des complaintes des habitants de Gros Caillou concernant l'opération d'un garage appartenant au chairman sur un terrain appartenant à cette compagnie? Et si c'est le cas, qu'est-ce qui a été fait pour soulager ces habitants?
We have not received any case of such complaint because, as I know from the council, that the garage exists from nearly 10 years above.
Next question. The Honorable Second Member for Rodrigue.
Thank you very much. B/884.
Mr. Deputy Speaker, sir, I would like to inform the House that households on the Social Register of Mauritius, SRM, who choose to sign the social contract with the National Empowerment Foundation, NEF, are provided with support through numerous schemes meant to empower these beneficiaries to move out of poverty. If these households comply with the requirements of the contract over a period of 2 years, they are provided continued support for 1 additional year. If the beneficiaries consider that they still need support after these 3 years, they may apply again to be on the Social Register of Mauritius. If they are found eligible, they are placed anew on the SRM and are called to sign a new social contract with the NEF. For Rodriguez, applicants have to submit their applications at any one of the 4 offices at the level of the Commission for Social Security falling under the RRA. I am informed that these applications are processed and visits are conducted by officers of the Commission within a month on average. The applications and reports of visit are then forwarded to the SRM unit of the Ministry of Social Integration, Social Security and National Solidarity, where the eligibility test is carried out at the end of each month. If found eligible, these families are notified and invited to sign the social contract with NEF. I am informed that the average time taken by NEF Rodrigue to process these contracts would be 1 month. Thus, it would be reasonable to state that the time between the application date at the Commission for Social Security of RRA and the finalization of the new contract with the beneficiary would take around 3 months. Mr. Deputy Speaker, sir, I am informed that as at 30 April 2026, there were a total of 6,888 households on the social register of Mauritius, made up of 4,301 households in Mauritius and 2,587 households in Rodrigues. This represents a total of 25,240 individuals, with 16,329 individuals in Mauritius and 8,911 individuals in Rodrigues. I am also informed that out of these, as at 30 April 2026, there were a total of 5,430 beneficiaries who signed the social contract and benefited from support from the National Empowerment Foundation, made up of 3,373 households in Mauritius and 2,057 households in Rodrigues. This represents a total of 20 individuals, with 13,093 individuals in Mauritius and 6,999 individuals in Rodrigues. Mr. Deputy Speaker, sir, the House may please note that payment on a monthly subsistence allowance is effected to all SRM eligible households that have signed a social contract with NEF by mid-month, systematically each month at the level of my ministry. This is the case for Rodrigues beneficiaries too. Thank you, Mr. Deputy Speaker, sir.
Yes, Honorable François.
Yes. Thank you, Honorable Minister. Thank you, Mr. Deputy Speaker, sir. May I ask the Honorable Minister, the visit, I understand, now taking longer than 1 month, whether his ministry and NEF is agreeable to consider paying overtime as it used to be at times to the limited number of staffs at regional assembly level. As I understand, we don't have the budget for same to expedite matters on these SRM, NEF cases, inquiries, when the list consists of, at times, more than 500 cases to attend to.
As it stands, and the law as it is, it's the Commission for Social Security is budgeted under the RRA. But according to my figures that I have, from the 1st of July 2025 and 31st of May 2026, the number of applications received was 1,614. And the number of visits affected was 1,444, which means nearly 90% of the application have been attended and visited. And the number of visits not affected is 170. I would consider this normal given the span of time. But if there is a need, I will meet the Commissioner of Social Security this Friday. I can raise the matter with him.
Honorable Minister, when you replied to me during an adjournment matter, will your ministry complete and implement a new review mechanisms of a system of approval and payment to you say 3 months, but I understand it goes beyond the 3 months. Are you coming with a new mechanism in that direction?
The 3 months is for Rodrigues and Mauritius too. Okay. But the whole process of the National Empowerment Program, the payment as well as social integration and empowerment is being reviewed in the context of the budget.
Okay, the next question, the Honorable Third Member for Beaubassin-Petite-Rivière.
B885. Monsieur le Vice-président, je suis sidéré par cette question quand elle est factually erroneous. Mr. Deputy Speaker, I have in my possession documentary evidence that the appeal of Mr. S.S., President of the Mauritius Football Association, was called for hearing on Thursday, 28, 2026, at the tribunal de première instance d'Antananarivo, but has been postponed to a future date. Thus, the question of the appeal is being dismissed, does not even arise, and most probably is but a figment of someone's imagination. Mr. Deputy Speaker, chronologically, notice of question are submitted to the clerk office not less than 4 days before the sitting of the Assembly, excluding Sundays and public holidays. Technically, this question must have been submitted by Wednesday, 27th May 2026. There is where the issue lies. How can an appeal be dismissed without even having been heard? I stand to prove wrong and invite the honourable member to lay a certified true copy of the judgment to which he is referring. Mr. Deputy Speaker, sir, the other part of the question are of no relevance.
Monsieur le Président, j'ai en ma possession, je ne sais pas si l'honorable ministre a quelque chose de différent, j'ai en ma possession des documents des verdicts certifiés, authentifiés, que je vais déposer. L'honorable ministre aura l'occasion, et vous-même, Monsieur le Vice-président, de jeter un coup d'œil. Et d'après ces documents, l'appel de Monsieur SS a été rejeté. C'est pour cela que j'ai adressé une question à l'honorable ministre de façon à ce qu'on puisse savoir quelle est la position de la MFA, quelle est la position de son ministère par rapport au verdict de l'appel de M. SS qui a été rejeté. Et cette affaire a été, permettez-moi, je termine, et cette affaire a été répercutée dans les médias et l'honorable ministre, je suppose, a dû certainement prendre connaissance de toute cette affaire. Alors, c'est pour cela que je suis venu avec cette question aujourd'hui, pour savoir quelle est la position de son ministère, quelle est la position de la MFA par rapport au verdict de l'appel qui a été rejeté.
You are going to lay this document? Yes, sure. Really? Say, let me have a look.
Si vous permettez, Monsieur le Vice-président,
Oui.
je leur ai dit que l'affaire a été renvoyée au 25 juin 2026.
Et avec votre permission,
Listen. Yes, you have an exception?
L'honorable ministre peut-il déposer, il vient de nous parler, je crois, du 26 juin, si je ne me trompe, est-ce qu'il peut déposer le document auquel il fait référence?
The document you have produced, Honorable Kiran, is a document where he has been sentenced, but it's not from the appeal court. He has been sentenced to l'action civile, but the Honorable Minister is referring to the appeal court. You want to leave the document as well? if you have?
Honorable Deputy Speaker, this document I have in my possession is a privileged information between Mr. SS and his counsel, which he has graciously shared with us and cannot be made public. However, my ministry has requested the Ministry of Foreign Affairs, Regional Integration and International Trade information regarding the case. I will share in due course.
Okay, we close it here because we are dealing with a foreign jurisdiction. We don't know the procedure there clearly, Madagascar. And as per the document you have produced, he has been sentenced at the first instance The minister is saying there's an appeal, so we will... Yes?
Émission.
Oui.
Je ne vois pas pourquoi l'honorable ministre ne veut pas déposer le document
He has
qui
been
est dans
advised
sa
that
possession.
he has been advised that it's a privileged document. We are talking about a foreign tribunal. Okay, Honorable First Member for Vacuan Foréal.
B 886.
Mr. the Deputy Speaker, sir, Mauritius has consistently maintained a principled and long-standing position in support of the legitimate rights of the Palestinian people, including their right to self-determination and the establishment of an independent, sovereign, and viable state of Palestine, in accordance with international law and the relevant resolutions of the United Nations. Our support for the Palestinian cause has been demonstrated over several decades through our voting record at the United Nations and its agencies, our support to decisions relating to Palestine at the African Union, our support for humanitarian initiatives aimed at alleviating the suffering of Palestinian civilians, and our participation in international legal and diplomatic processes concerning the question of Palestine. Mr. the Deputy Speaker, sir, as regards Part A of the question, diplomatic relations with Israel were established shortly after the accession of Mauritius to independence on the 23rd of April 1968. However, on the 7th of July 1976, Mauritius severed diplomatic relations with Israel in line with the position adopted by many African states and in solidarity with the Palestinian people. Mauritius subsequently recognized the Palestine Liberation Organization in 1979. Diplomatic relations with Israel were re-established on the 29th of September 1993, following the signing of the Oslo Accords between Israel and the Palestinian Liberation Organization. On the 15th of May 1996, Cabinet agreed to the reopening of a honorary consulate of Mauritius in Tel Aviv. In 2009, under the Prime Ministership of Dr. the Honorable Navin Ramgoolam, in the wake of Israel's bombardment and continued escalation of Israeli military action in Gaza, Cabinet agreed to consider reviewing the operation of the Honorary Consulate of Israel in Mauritius. Thereafter, the request for the accreditation of the Israel ambassador in Pretoria was kept in abeyance until 2015, and the Israel ambassador presented its credentials only in 2018. Although diplomatic relations have not been formally severed, the current government has maintained a restrained approach to bilateral engagement, consistent with our long-standing support for the rights of the Palestinian people and our commitment to the principles of international law. This is reflected in the modest volume of trade between the two countries, the limited scope of bilateral cooperation programs, the absence of significant recent bilateral agreements, and the lack of high-level political exchange. Mauritius continues to uphold its fundamental principles regarding the inalienable rights of the Palestinians to self-determination. In this regard, Mauritius will today itself vote in favor of the participation of Palestine in the International Labour Organization as a non-member state. As regards Part B of the question, in particular the proceedings under the Genocide Convention instituted by South Africa against Israel before the ICJ, Mauritius is closely following the proceedings, and a decision on the need to intervene in the proceedings will be taken at a convenient stage in consultation with our missions in New York and Geneva. However, it is to be highlighted that the Mauritian government has publicly stated that it supports the case entered by South Africa in 2023. This was stated in this assembly by the then Minister of Foreign Affairs in July 2024, and there has been no change in policy on this issue by the current government. Any decision to intervene in the proceedings before the ICJ will be taken in a manner that is consistent with our national interest, our international obligations, and our enduring commitment to justice, multilateralism, and respect for international law. In this regard, Articles 62 and 63 of the Statute of the ICJ provide distinct mechanisms through which a state may seek to participate in proceedings before that court. Article 62 allows a state to request permission to intervene where it considers that it possesses an interest of a legal nature that may be affected by the court's decision. Such intervention is subject to the authorization of the ICJ. Article 63, however, provides for intervention by states that are parties to a convention where interpretation of that convention is in issue in the proceedings, allowing them to present observations on the interpretation of that convention. So far, 19 countries have filed declarations supporting the case for South Africa, and 3 have opposed the case so far. The majority of these countries have filed declarations under Article 63 in order to provide their inputs to the interpretation of the relevant provisions of the Genocide Convention. It has to be noted that countries intervening under Article 63 are restricted to give their views on the interpretation of the Convention and not on the substance of the case. Any decision by Mauritius to intervene in the proceedings will be based, therefore, on a rigorous assessment of the applicable legal requirements, the objectives to be achieved, and the extent to which Mauritius could make a meaningful contribution to the proceedings. In the meantime, Mauritius will continue to support all efforts under the aegis of the United Nations aimed at securing an immediate cessation of hostilities, ensuring the protection of civilians, facilitating unhindered humanitarian assistance, and advancing a just, comprehensive, and lasting solution to the Palestinian question.
The Honourable First Member for Port Maritime, yes.
B/887.
Mr. Deputy Speaker, sir, I am informed that as per records held by my ministry as at the 25th of May 2026, 19,149 leases have been granted over state lands classified as non-pagiometric, and 6,410 leases have been granted over pagiometric. In addition, 897 leases have been granted specifically in respect of ex-CHA houses situated on pagiometric. Let me hasten to add that those figures are leases that predate my coming into office as Minister of Housing and Land. We may add 5 leases ever since I've come, at the most, and nothing more than that. With regards to the total rental arrears, I am further informed that as at the 31st of December 2025, the outstanding amount stands at approximately, hold your horses, 1.3 billion. On this figure, 647 million has remained outstanding for a period exceeding 3 years. Now, what I have done in order to proceed with regards to the recovery of those amounts owed to the state, in August 2025, recovery action was initiated as regards campement site leases by notice against defaulting campement site lessees carrying rental arrears totaling approximately 43.99 million to effect payment within a period of 1 month ending the 28th of September 2025. Following that, as at date, some 20 million has been recovered out of the 43.99 for campement site leases. 62 lessees have been referred to the SLO under my instructions for legal actions for recovery of arrears in rent and premium due. For industrial site leases, this is where the amounts are quite immense. With regard to industrial site leases in arrears of rental payments, information has been compiled to exclude, inter alia, cases involving ongoing courts proceedings and cases where payment facilities have been requested and any other matters that may affect the issuance of notice. Once the relevant statement of claims is generated, notices are issued requiring the lessees to settle all outstanding rentals within a period of 1 month from the date of such notice. Now, as at the 1st of June 2026, 65 notices have been issued to recoup outstanding arrears. And those 65 notices are the lion's share of the 1.3 billion rupees that is owed. Let me conclude, Mr. Deputy Speaker, by saying that many of those lessees over the years have played a very important and interesting, important to them, but interesting little game. And that game has been to avail themselves of a particular section of the Civil Code. That particular section of the Civil Code states that we cannot, it is barred by a maximum of 3 years. And you cannot, once you claim, go further than the 3 years. So what they do, finally, is not pay. And then you have successive ministers of housing and governments who come in who do nothing, like our absent friends. And what happens is that the debt goes up, and then they take advantage of the 3 years. But this is not going to be the case anymore. Because true it is that the Civil Code says we can go only as far back as 3 years to claim, but it does not in any way remove the possibility of me cancelling the lease de plein droit. Even if it's at a hotel, even if it is a running business, even if it is a beautiful 5-star hotel, you owe money to the state, you will pay. Otherwise, I will cancel the lease and you will have no door to knock upon. Maybe go to court, but in the meantime, the lease will be cancelled.
Merci, Monsieur le Vice-président. Monsieur le ministre, c'est hallucinant. 1,3 milliard, l'argent de contribuables qui aurait dû être dans la caisse de l'État. Déjà, on est à court de fonds pour divers projets. Mais, Monsieur le ministre, vous avez parlé de 3 ans time bound. Et déjà, il y a 650 millions qui ont déjà dépassé 3 ans. Qu'est-ce que vous comptez faire pour faire entrer cet argent ou sinon révoquer le contrat?
Monsieur le député, let me say the following. You see, I have practiced law for many years, and I myself have taken advantage, Mr. Deputy Speaker will understand what I'm getting at, when something is, the civil code is there and helps you out, your client's liability, if ever you represent such clients, you're limited to 3 years. Fair enough. But as I said, I will not run away from, you pay your 3 years, but you'll get a cancellation of the lease at the same time. However, should you wish to maintain the lease and for it not to be cancelled, you enter into the reconnaissance de dette, whereby you accept owing the state the full amount, and you pay whatever you owe. Failing which, you shall lose the industrial site lease and whatever comes and stands on it without any necessity for compensation.
Yes.
Merci, Monsieur le Vice-président. Monsieur le ministre, et 650 millions de roupies. Combien de ces 650 millions de roupies, des contrats ont été renouvelés depuis les dernières années, qui ont 3 ans de dette?
Ever since I have been in office, the answer is none. So you see, whenever you have situations whereby they owe money, my main objective, and those are the instructions I have from government and the Prime Minister, that we have to recover that whatever is owed. So what I do, in fact, is ensure that they pay what they have to pay. Unless they have been giving facilities by the then Minister of Finance, that is another matter to deal with.
Yes, thank you, Mr. Speaker, sir. Being given that there are large amount of rent in arrears from the leaseholders, I'm referring particularly to the residential leaseholders who have been occupying the state land and the pas géométrique for perhaps half a century. Would the minister consider the possibility of amending the legislation so as to grant the freehold title to those leaseholders in order to alleviate the situation and to overcome the problem of rent due at the same time?
The issue that the honourable member raises is indeed a real issue, and my colleague, the Honourable Minister of Foreign Affairs, has many times drawn my attention to that particular issue. Let me therefore say that many of those people living in such situations on pas géométrique have lived there for generations, and they are continuously in a situation where they have to pay rent. Okay? So the lease that they have to pay itself sometimes is less in terms of total that is recovered than the administrative cost that we have to invest in order to recover it. So therein lies a nonsensical situation. I have at some point considered the possibility of selling the land to them. But at the same time, it would also mean many of those are not necessarily those at the low income group. Many have been successful through efforts, through investment, through energy deployed by their parents and grandparents, and I take note of that. But I don't want to be put in a situation where millionaires, who happen to be quite a few among them, not many, would also benefit from a free plot of land when the state should recover money. So what I'm working on at the moment at the level of my ministry, many plots of land of pas géométrique, I've said this in this assembly, I'm saying it again, at one point in time were sold in violation of the law. And all those sales are null and void. They have been resold and sold again, and title has passed. But each of those titles that have passed, Mr. Deputy Speaker, sir, is null and void because it is inalienable. You cannot alienate, you cannot sell pas géométrique. This is against the law. There was a wrong move by a certain time by a certain minister who sold pas géométrique. And that was even registered at the Registrar General. Wrong, unlawful. So what we intend to do is, in fact, nullify all those sales. We're working on that. Nullify all those sales and give all of them a buy for 99 years for 1 rupee. That is a possibility because we would be saving money in the process. But to give away pas géométrique, selling it, that is against the law, and we will have to correct that wrong in the law.
Next question, Honorable Savabadi.
Thank you, Mr. Deputy Speaker, sir. Question B888.
Mr. Deputy Speaker, I wish to inform the House that in a correspondence dated 1st September 2025, my ministry was notified by the Prime Minister's office that approval had been obtained for A, the conversion of 2 buildings used as rehabilitation youth centers, or YCs, into dedicated specialized institutions for children with serious behavioral concerns, CSBC, and B, that the centers would be managed by my ministry and the secondment of 39 of the OYC's officers for a mutually agreed period. Mr. Deputy Speaker, on 4th September 2025, a meeting was held at the Prime Minister's office with ministers of my ministry to discuss the implementation thereof, following which a site visit was effected at the OYC premises on 25th September 2025 by senior officers of the PMO of the Office of the Director of Public Prosecutions and my ministry. Mr. Deputy Speaker, on 26 January 2026, a draft MOU was submitted by the Prime Minister's office outlining the modus operandi on the administrative arrangements and operational management of a revamped rehabilitation youth of revamped rehabilitation youth centers. These require extensive discussions and consultations between the stakeholders. I wish to inform the House that the challenge of dealing with CSBC requires a strategic approach, and therefore a committee co-chaired by the Attorney General and myself was set up. Therefore, the draft MOU has been kept in abeyance pending the recommendation of the committee. The committee comprises the Chief Government Whip, the Honourable Ms. Stéphanie Anctil, the Honourable Dr. Babita Tanou, Member of the National Assembly, representatives of the Office of the DPP, the Probation Office, the Police, as well as officers of my ministry, the Prime Minister's Office, and that of the Attorney General's Office. This committee was established in order to come up with concrete solutions in addressing the existing gaps concerning CSBC and those in conflict with the law. A first meeting was held on 4th February 2026, at which the stakeholders present were requested to submit proposals aimed at addressing loopholes in the current legislation framework, policies, and infrastructural arrangements. On 10th March 2026, a second meeting was held to take stock of the proposals received. Given the complexity of the issues, the committee considered it more appropriate to establish two distinct subcommittees, one dealing with matters involving children with serious behavioral concerns, and the second one regarding children in conflict with the law, in order to undertake an in-depth analysis of the submissions made by all stakeholders concerned. A third meeting of the main committee was held on 29th April 2026, to which the Honourable Minister of Education and Human Resources and the Ombudsperson for Children were also invited. Mr. Deputy Speaker, during that meeting, it was agreed that there was need for an infrastructural facility specifically designed to cater for children with serious behavioral concerns, separate from children who are in conflict with the law. Thus, consideration would be given to the requisite RYC infrastructure and trained staff being dedicated to an institution which would centralize service delivery for children with serious behavioral concern. A fourth meeting of the committee was held on 21st May 2026. Following discussions, it was agreed that the new institution would be operated by a parastatal body, which would be under the aegis of my ministry. The new institution would be situated within the premises of the RYC, which will be upgraded in order to meet the standards of an institution for care and protection of children while taking into consideration the requirements of CSBC. The new multidisciplinary body, which would be staffed, among others, by the professionals formerly working in the RYC, would address the education and psychological needs of CSBC. It was therefore proposed that an interim report be drawn and government be apprised of the work conducted by the committee and seek approval for its implementation as soon as possible. Mr. Deputy Speaker, with regard to an expected implementation date, a definite time frame cannot be given at this stage. However, the House should rest assured that this matter has the attention of this government.
Yes, Honourable Member.
Merci, Monsieur le Vice-président. L'honorable adjointe au Premier ministre peut-elle dire à la Chambre si les recommandations appuient le transfert du Rehabilitation Youth Center à son ministère? Merci.
Tout sera dans le rapport qui sera soumis au cabinet.
Thank you. The Honourable Second Member for Gambé-Pouledo.
Thank you, Deputy Speaker, sir. B889.
Yes, Mr. Deputy Speaker, sir. I am informed that the Saint-Antoine Planters Cooperative Trust was set up following the closure of Saint-Antoine Sugar Factory under the Saint-Antoine Planters Cooperative Trust Act No. 28 of 1994. It became operational in March 1996. The purpose was to provide financial and material support to planters who previously delivered sugarcane to that factory. The trust receives and manages funds contributed by the Compagnie Sucrière de Saint-Antoine Limited. The funds are exclusively used for the benefit of planters in the ex-Saint-Antoine factory area, in accordance with the object set out in the Act. Mr. Deputy Speaker, with regard to Part A of the question, I am tabling the composition of the board, which was reconstituted on 10th October 2025. With regard to Part B of the question, I am informed that the actual fund of the trust amounts to 88 million rupees, out of which the trust holds savings account totaling to around 6.3 million and a current account of 200,000, and the rest are fixed deposit. The trust is entitled to expenses reasonably incurred in the management of the fund, provided that the expenses do not in any year exceed 1% of the net current value of the fund. I am further informed that the trust continues to manage its financial resources prudently in accordance with the provisions of the Act as established financial procedures. Mr. Deputy Speaker, sir, with regard to Part C of the question, I am informed that the Trust operates several loan schemes, grant schemes, and support projects for the benefit of planters in the ex-Saint-Antoine sugar factory area, which includes Goodlands and surrounding regions. The following measures and action plan are envisaged up to December 2026. For loan schemes, the technical subcommittee of the Trust reviewed the existing loan scheme in February 2026 in view of the increasing costs of sugarcane cultivation and recommended revised rates for crop year 2026. The revised proposals include increases in the ceiling for new plantation loans, derocking loans, one-year crop loans, and loans for the purchase of agricultural equipment and transport facilities. These proposals were approved by the board on March 2026, 5 March 2026, and are operational as from March 2026. However, no application has yet been received. As regards to grant schemes, I am apprised that the Trust presently operates a grant for cutting, loading, and transport, a grant for the purchase of sprayers, and a fertilizer grant for new plantation. With regard to the grant of cutting, loading, and transport, I am informed that for crop 2025, 70 planters have benefited a total amount of 324,000 rupees. For crop 2025, 27 additional applications have been received, amounting to 185,000, which have been favorably considered at the board meeting held on the 26th of May this year. If the Trust receives more applications, they will definitely be entertained. Mr. Deputy Speaker, with regards to projects and schemes implemented specifically in Goodlands over the period 2015 and 2024, I am informed that the Trust does not implement projects for specific village or region in isolation. All projects and schemes are implemented for the benefit of planters within the entire ex-Saint-Antoine sugar factory area, which includes Goodlands and surrounding regions. Nevertheless, I am informed that projects and schemes have been executed in Goodlands region as part of the wider area for road mending works during the period 2016 to 17 to facilitate access to agricultural fields for the conveyance of sugarcane. The total amount disbursed under road mending projects in the Goodlands area and other regions came up to around 991,000 and to a total of 2,480 meters for roads repaired as at June 2016 and 1.2 million for a total of 4,050 meters for roads repaired as at June 2017. Mr. Deputy Speaker, I am informed that planters in Goodlands, as part of ex-Saint-Antoine sugar factory area, benefited from grant schemes relating to cutting, loading and transport, fertilizers and sprayers during the period 2016 to 24, amounting to approximately 1.4 million rupees. Whilst for the purchase of sprayers and fertilizers, an approximate amount of 15 to 73,000 rupees were granted. Furthermore, over the same period, road mending projects overtaken at Goodlands for 2,530 meters of roads for an approximate amount of 593,000. Yes.
Yes, Honourable Bijan.
Thank you, Deputy Speaker, sir. Can the Honourable Minister inform the House whether the board has conducted any formal consultation, surveys or meeting with planters to identify their priorities or needs? If not, will consideration be given?
Yes, there was a technical subcommittee that met rather on the 9th February this year to review areas of concern for planters. For example, loan schemes, grant schemes, among others. And I must say that should any request be made, project and schemes that would be executed in Goodlands for any particular projects be submitted in the future, they may be favorably be entertained by the trust, provided they fall within the authorized financial parameters.
Last question.
My last supplementary. Yeah. In view of the importance of agriculture in the northern region, will the Honourable Minister indicate whether the board has established measurable targets and key performance indicators for the next financial year?
Yes, indeed. It came to my attention that this year the technical subcommittee further recommended that the grant for cutting, loading and transport be increased from 100 rupee to 150 rupee per ton of cane produced for crop year 2026, given the rising operational costs faced by planters. This measure will be effective as from the 1st of July, that is next month. And concerning the mechanization support, the Trust has apprised that this year the technical subcommittee has also initiated discussion on the forthcoming measures to assist planters in mechanizing their lands to benefit from mechanical harvesting facilities, and further consultation are being held on this matter.
Honourable Second Member for Mayberg, Mayon.
Yes, thank you, Mr. Deputy Speaker. B890.
Mr. Deputy Speaker, sir, I'm informed by the Medical Council of Mauritius that the number of registered specialists in the following specialities is as follows: vascular surgeons 2, cardiovascular surgeons 5, interventional cardiologists 1. In addition, 74 cardiologists and 10 cardiothoracic surgeons are also registered with Medical Council. Many cardiologists are also trained and are performing interventional cardiologists. Mr. Deputy Speaker, sir, regarding part A of the question, I'm first informed that there are 2 funded posts on my ministry's establishment for vascular surgeons. Unfortunately, one passed away and the second one resigned from service. Currently, there is no vascular surgeon working in the public hospitals. I wish to inform the House that an advertisement for the post of vascular surgeon was launched at the level of Public Service Commission on 24th April 2026 with a closing date on 14th May 2026. I'm informed that no candidate has applied for the post. Regarding the field of cardiology, 19 cardiologists are working in public health institutions, and there is only one vacancy. As such, an advertisement was launched on 10th of March 2026 by Public Service Commission, with a closing date on 30th March 2026. To date, the vacancy had not yet been filled. Mr. Deputy Speaker, sir, with regard to cardiovascular surgeons, there are no cardiovascular surgeons employed by the ministry. However, the level of cardiac center Pamplemousses, there are 4 cardiac surgeons who are currently practicing at the center. Mr. Deputy Speaker, sir, with regard to Part B of the question, my ministry, with assistance of World Health Organization Country Office, has started an assessment to evaluate the shortages in various medical specialties, including vascular surgeries and cardiovascular surgeries. A report with its recommendation is expected shortly. As a caring government, my ministry is leaving no stone unturned in the field of high-tech medicine, keeping in mind the welfare and well-being of the patients. Every avenue is being explored, including visits of specialized surgical experts from foreign countries, including India, United Kingdom, South Africa, France, Australia, United States of America, to carry out complex surgical interventions in public hospitals. Currently, there is a team comprising a cardiac surgeon from Krishna Institute of Medical Sciences, Hyderabad from India, who is carrying out delicate cardiac interventions at Saj Hospital. My ministry is also expecting a second team by next week. In addition, my ministry regularly receives a visit of Dr. Ritu, an eminent consultant in vascular surgery from United Kingdom. Dr. Ritu, who is a Mauritian born, has carried out more than 100 cases on a voluntary basis. Moreover, 11 complex onco-surgeries have been carried out at the National Cancer Center, with over 90% success rate by 2 doctors from Chennai, India. I wish to inform the House that my ministry has also invited eminent doctors from India to clear approximately 2,200 cataract cases, which will be done in around 2 months' time. Mr. Deputy Speaker, sir, the key reasons for these frequent visits are that the visiting teams can provide expertise in different areas, and this creates an opportunity for our local doctors, nurses, and technicians to work alongside these experienced specialists for hands-on training, exposure to new techniques, and continuing medical education. Foreign surgical missions often perform many surgeries within a short period, thus help reducing the waiting time for patients to be operated. Visiting teams to bring specialized equipment or expertise in newer, minimally invasive or highly complex procedures that may not yet be widely available within our setup. Bringing foreign specialists to operate within our hospital to help in the reduction of associated costs in connection of sending patients abroad for overseas treatment. Patients have access to specialized high-tech medicine locally, and there is no need to travel abroad for such interventions. I can reassure the House that sustainable progress will be achieved by a holistic response, including capacity building, building bilateral or multilateral collaboration with foreign countries. I am confident that we can truly ensure life-saving care for patients, and no patient is left behind. My ministry is working with the Ministry of Finance to put in place a special scheme to enable the recruitment of foreign doctors in specific fields where there is lack of qualified personnel. It's worth noting that dozens of doctors from India have been helping our country on a purely voluntary basis in different fields, such as onco-surgery, pediatric oncology, vascular surgery, neurosurgery, renal and multi-organ transplant, among others. I wish to inform the House that during my recent visit to Geneva in the context of the 79th World Health Assembly, I had the opportunity to have a working session with Mr. G.P. Jatta, the Health Minister of India, who agreed to consider providing assistance in specialized fields.
Honorable Apollo.
Thank you, Mr. Deputy Speaker. Can I ask the Minister if his ministry has received any complaint from patients as their treatment is being delayed for lack of specialists?
I have already mentioned that we have got hardly specialists left in specific fields, and that is the reason why we are turning towards our donor country to help us. They have to be a bit patient, because we definitely, as I have just mentioned, that we are leaving no stone unturned to help those patients.
Deputy Speaker, Honourable Minister, since you said we have no vascular surgeon in our public hospitals, can you consider to refer vascular patients to private clinics?
Even in private clinics, if I'm not mistaken, there is one vascular surgeon who is in the Army hospital. So when we do get such cases, well, I have no hesitation to refer them. But actually, we are having one foreign doctor who is working with us, and actually he's operating. But if in case the need is felt, I don't have any hesitation in referring them to the private clinic.
The Honourable First Member for Savannah Black River.
891.
Thank you very much. Mr. Deputy Speaker, from information obtained, all the 61 fish landing stations are operational.
Yes.
May I ask the Minister if he has done a survey and tell me exactly where are those operating ones? Because as per my informations, most of them are closed.
I have a list here which I'll obligingly circulate, okay, and you can peruse at your own leisure. Thank you.
Thank you. The Honourable Second Member for Rodrigue.
Thank you. Stroke 892.
Mr. Deputy Speaker, following the budget 2025-2026, I am informed by the DBM, Development Bank of Mauritius, that the Women Entrepreneur Loan Scheme was reviewed. The maximum credit limit on the loan was raised from 500,000 rupees to 1.2 million rupees. The scheme is designed to provide financial assistance to women for the establishment and development of income-generating activities. I'm also informed that following the budget 2025-2026, all DBM loans under the Women Entrepreneur Loan Scheme carry a moratorium of 18 months for repayments instead of 12 months, during which only interest is payable. Thereafter, capital and interest are repayable over a maximum period of 5.5 years. I am further informed that eligibility for the scheme extends to women entrepreneurs who have business registration number, as well as companies in which women hold majority shareholding. Under the scheme, women are eligible for a maximum of 1.2 million rupees at an interest rate of 0.5% per annum. Moreover, a general floating charge on the assets of the women entrepreneur is taken as guarantee. Mr. Speaker, sir, with regard to Part B of the question, I am informed by the DBM Limited that for the period 1st July 2025 to date, for mainland Mauritius and Rodrigues, 69 applications were received altogether for a total amount of 40,825,550 rupees, of which 39,426,000 rupees has been approved and 30,086,187 rupees has been disbursed. The breakdown of these figures is as follows. A, for mainland Mauritius, 68 applications were received for a total amount of 40,475,000 rupees and 550 rupees, of which 39,096,000 rupees has been approved and 30,086,187 rupees has been disbursed. For Rodrigues Island, one application was received on 17th March 2026 for a total amount of 350,000 rupees, of which 330,000 rupees has been approved on 23rd April 2026 and 287,500 rupees has been disbursed.
The Honourable Second Member for Mayberg, Planmayon.
Thank you, Mr. Deputy Speaker. B893.
Thank you very much. Mr. Deputy Speaker, sir, I wish to inform the House that a technical committee was set up at the level of my ministry to look into the relocation of pig breeders at Le Bouchon. Now, the committee noted that the pig breeding activities at Le Bouchon were carried out by 7 pig breeders with 300 and 34 hens. That the activities were being carried out on private land, although, as far as I know, I can query whether it's private land. There is a long story over the legitimacy of those who claim that it's private land. Now, C, as per the Environment Act, pig rearing forms part of the list of undertakings requiring a preliminary environment report. And D, pig breeders were also required to have a building and land use permit from the district council to carry out the activities. Mr. Deputy Speaker, since the owner of the said land was unknown, the assistance of the Ministry of Housing and Lands was sought, and the ownership of the private land was communicated to my ministry. Now, a site visit was effected on the 11th March 2026 by a representative of the Food and Agricultural Research and Extension Institute and the Ministry of Housing and Lands. With regard to the building and land use permit and preliminary environment report, I'm informed by the Ministry of Local Government and Ministry of Environment, Solid Waste and Management and Climate Change that these breeders, unfortunately, do not have the required permit and are operating illegally. Mr. Deputy Speaker, sir, pig farming produces significant organic waste, often causing environment harm and health risks. Hence, the relocation of pig breeders from Le Bouchon is necessary, taking into consideration the environmental and biosecurity concern. Furthermore, with a view to addressing the issue of pig breeding activities in a holistic manner, an interministerial committee has been set up, and the first committee was held on the 5th of March 2026 under the chair of our colleague, Honorable Shakil Mohammed. The committee is inter alia looking at solutions for pig waste treatment, to pig breeding around the island on state and private lands, 3, way forward with regard to illegal pig breeding activities, and 4, engagement of all stakeholders from public and private sector to address the issue of pig breeding. Mr. Deputy Speaker, so my ministry launched an expression of interest for collection of pig waste and its transformation into biogas, following which 2 companies have submitted their proposals. Same is at evaluation stage at my ministry's level. In addition, a tender was launched on the 30th April 2026 for consultancy services for the proposal and design of pig waste treatment facility for conversion of biogas to electricity at the Saint-Martin pig farm, with closing date of 12 June 2026.
Yes.
Thank you, Mr. Speaker. Thank you, Minister. Can I ask the Minister if any land has been spotted nearby the Bouchon to relocate these pig farmers breeding?
Land was spotted, but unfortunately, because of high water table and wetlands, unfortunately, the site wasn't appropriate. That's why we are erring on the side of caution. The committee is looking, into issues relevant to pig breeding. It is unfortunate also that only 128 pig breeders have registered. And even then, they are operating illegally because none of them have what we call building and land use permits. So that's why we say the approach has to be holistic. We are looking at all the issues relevant. And I've also taken the decision that no permit for pig rearing would be given. Thank you.
Honourable Second Member for Gambé-Pouldo.
Thank you, Mr. Deputy Speaker. Sir, B894.
Mr. Deputy Speaker, sir, I would like to refer the Honourable Member to the reply I made to PQ A4 on 28 October 2025 regarding traffic congestion at the Daruchi and Vale Junction. Mr. Deputy Speaker, sir, the heavy traffic congestion occurring along the bypass from the Goodlands roundabout up to the Espace Maison Rouillard roundabout, that is the fallback roundabout, is not an isolated issue. In fact, technical assessments indicate a significant shockwave effect originating from the Labourdonnais and Mapu roundabouts. The backup traffic queue eventually cascades down to the fallback Espace Maison roundabout, creating a major obstruction for vehicles coming from the Goodlands bypass that attempt to join the motorway M2. Mr. Deputy Speaker, sir, with regard to part A of the question, I'm informed by the Traffic Management and Road Safety Unit that its traffic modeling unit has recently undertaken a comprehensive traffic modeling exercise to identify the most effective infrastructure proposal for enhancing traffic fluidity along the motorway M2 corridor, specifically for commuters traveling from Labourdonnais and Mapu regions towards Port Louis and vice versa during peak hours. The traffic modeling concludes that the existing infrastructure is currently in a state of total corridor failure characterized by severe traffic delays. The traffic modeling confirms that the motorway M2 between Mapu and Labourdonnais functions as a single interconnected system. At grade, improvements such as the implementation of slip lanes only are insufficient to support the long-term traffic growth on this corridor. Also, the upgrading of only one of the two roundabouts is counterproductive. This intervention triggers a collapse of the adjacent node due to the increased rate of vehicle arrivals. In this context, the TMRSU has informed the RDA that it recommends the implementation of dual flyovers, grade-separated junctions, at both Mapu and Labourdonnais roundabouts. This option is expected to achieve an optimal level of service while maintaining existing local access patterns and safeguarding the existing public transport routes. The TMSU further recommends the construction of a link road between Beau Plateau Road, B43, and Middle Road, B17, starting from a new roundabout at the sharp bend of B43 Road, which passes on the outskirts of Mapu village. The RDA has examined this option, but is proposing the construction of a new bypass linking Beau Plateau to Mapu. This bypass would streamline traffic between the two roads without requiring access to motorway M2. Additionally, replacing the sharp bend with a roundabout along the B43 road will significantly enhance safety along that segment of the road. Accordingly, a request has been made in the budget 2026-2027 for the provision of funds for this project. Mr. Deputy Speaker, sir, the junction of Mapu Goodlands Road, A5 Road, and the Vale Road, B12 Road, is a signalized T-junction. It has been observed that during peak hours, there is a high volume of traffic coming from A5 Road and Goodlands Bypass, A13 Road, wishing to right turn to accede onto B12 Road. As such, the vehicles have to wait for either a safe gap to perform this right turn movement, or vehicles coming from motorway M2 provide the right of wait as a courtesy for vehicles on A5 to right turn onto B12 Road. In doing so, traffic queues quickly build up. This high volume of right turning traffic movement during peak hours is the primary cause of queuing at this signalized T-junction. Mr. Deputy Speaker, sir, I'm further informed by the TMSU that it has, as an immediate measure, provided for a shorter time of the green traffic signal for the leg coming from the motorway M2, that is stopping the vehicles along this leg and simultaneously increasing the green light time for the traffic signal along A5 Road to cater for the high volume of right turning traffic movement. This measure is intended to give the high volume of right-turning vehicles on A5 Road more time to clear the intersection and thus provide immediate relief to the queue buildup. Mr. Deputy Speaker, sir, with regard to Part B of the question, I am informed by the RDA that with a view to solving the traffic congestion problem at junction Daruti and Vale, the TRMSU has asked the RDA to improve the junction by constructing a slip lane from the Mapu Woodlands Road towards Vale Road B12. However, this project will require the acquisition of private land. A request for land acquisition has recently been made by the RDA to my ministry, and action has been initiated for land acquisition. Mr. Deputy Speaker, sir, I would also like to highlight that I recently announced the implementation by my ministry of the motorway M4 project, which will start in the region of Faubac, near the Espace Maison roundabout. This new motorway project will be an alternative route and is expected to contribute substantially to the decongestion of the existing road networks in that region, including the northern corridor. The project also comprises a grade-separated junction along the motorway M2 at Faubac to significantly improve the fluidity of traffic in that region. The works are expected to start during the next financial year to be completed some 32 months later. It is therefore premature to consider the construction of an additional lane from Goodlands roundabout to Faubac. Once the motorway M4 project would be completed, an assessment would be conducted to find out whether there would be need for the construction of the additional lane. Thank you.
Yes, thank you, Deputy Speaker. Can the Honourable Minister inform the House, was there any representation by former elected members of previous government have been received at the Ministry concerning the daily traffic congestion pending over there, Goodlands Darity, since many years?
As far as I've seen in the files, I have not seen any question or any request from MPs. But however, I appreciate that you raised the question of congestion in that region.
One last question. Yeah, thank you. In view of rapid residential and commercial development taking place in the northern region, more precisely at Goodlands, Péchirafé, Kalojin, Rocheter, Grand-Goup, will the Honourable Minister indicate whether a comprehensive traffic management plan is being envisaged for these particular areas to ease the traffic flow?
But this is what I said in my answer. So we have a comprehensive study, and now we will be working on B43, that is from Beau Plateau to Mapu, that is at the back, passing at the back of École Labourdonnais, in order to bypass that region and they go to Mapu. And then we have the M4 road project which is coming, so we'll have to assess all these once they are completed, how they are working.
You have a question on this?
Le ministre a confirmé dans sa réponse que le gouvernement ira de l'avant avec le motorway M4. Le ministre peut-il indiquer si le gouvernement considère qu'une étude de faisabilité datant de 2012 est suffisante pour engager un projet dépassant 10 milliards de roupies dans le contexte économique et démographique actuel? Et dans la négative, pourra-t-il indiquer à la Chambre si une étude actualisée sera faite?
First of all, let me thank the government of India for assisting us in having this project to come on our pipeline for the next financial year. Because without the Indian grant and loan support, without the support of Indian government, we would never have been able to undertake this project. And this project dates back 20 years. Government after government knows that we have to connect the north with the east and eventually with the south. Now, there was an EIA which has been done. We are, despite that there has been an EIA, we are updating and the EIA and our local consultants. There will be the local consultants which have worked on the project, the same local consultant that has been, their services have been retained, and the Indian side have accepted that the local consultant will work on that. So they are doing everything to review the EIA and all. Tout a été fait, tout va être fait, mais on apprécie et on remercie le gouvernement de l'Inde pour nous aider pour faire ce projet.
You have another one on the same issue?
Yes, sir.
Or your next question?
No, it's the same issue. Since the minister is talking of a master plan for that region, will you consider the rehabilitation, total rehabilitation of the fallback road that will make together in the road system there?
Yeah, this is what I said, because the fallback region, where you have a Space Maison, you have, the fallback road will be taken care when we are working on the M4 project. All these will be taken care of.
The Honourable Third Member for Gourmet, now your question.
B895, B895, please. Thank you.
Mr. Deputy Speaker, sir, I am informed by the District Council of Givenchy that from 1st January 2025 to date, 113 building and land use permit, that is a BLUP, applications have been received in respect of the region of Kalojin, comprising 67 residential development, 34 subdivision excision project, and 12 commercial developments. I'm tabling a detailed schedule showing each application and its current status. I'm further informed that 2 objections have been received in relation to proposed non-residential development, namely a proposed car wash and a proposed apartment development. As no formal BLUP application has yet been submitted in either case, no permit has been issued, and thus no assessment has commenced. The objection has nevertheless been duly recorded and will be considered should formal BLUP application be submitted. Mr. Deputy Speaker, sir, all applications are assessed on an individual merits and in accordance with the Planning and Development Act 2004, Local Government Act, the Planning Policy Guidance, the relevant technical sheet and other application law, regulation and planning standard. The submission of the application does not confer any automatic entitlement to a permit. In determining an application, the local authority consult and take into consideration, where applicable, the recommendation, technical advice, clearances, and statutory requirements of the relevant authorities, including the Land Drainage Authority, Road Development Authority, Irrigation Authority, Traffic Management and Road Safety Unit, Ministry of Environment, Solid Waste Management and Climate Change, National Ramsar Committee, and other wetland authorities, Forestry Services, Mauritius Fire and Rescue Services, Central Water Authority, Central Electricity Board, and Wastewater Management Authority. Mr. Deputy Speaker, sir, where required by law, development may also be subject to an Traffic Impact Assessment, that is TIA, Preliminary Environmental Report, PER, Environment Impact Assessment, EIA, Strategic Environmental Assessment, CEA, or any other statutory clearance deemed necessary by the competent authorities. This assessment ensures that adequate consideration is given to infrastructure capacity, road access, traffic circulation, drainage, flood risk, utility services, environmental protection, public health and safety before any development is authorized. I'm further informed that no specific development plan currently exists for the region of Kalojin. Subsequently, applications are assessed on a case-to-case basis within the existing planning framework and in accordance with the recommendation of the relevant technical authorities. Mr. Deputy Speaker, I am informed by the Ministry of Environment, Solid Waste Management and Climate Change that Part A, B, and C of the 6th Schedule of the Environment Act 2024 prescribe undertakings that may require a preliminary environmental report license, an environmental impact assessment license, or a strategic environmental assessment, depending on the nature, scale, location, and likely environmental impact of the proposed development. Section 30, Part 3 of the Act further empowers that the minister responsible for environment to declare an undertaking as a scheduled undertaking requiring such approval where circumstances so warrant. The ministry has also confirmed that no PER or EIA license has been issued in respect of any project located in Kalojin during the past 10 years. Mr. Deputy Speaker, sir, regarding report of deregulating activities in the region, I am informed that the matter falls under the jurisdiction of the Ministry of Environment, which has already issued a stop order and is monitoring the site through the relevant enforcement authorities, including the Police de l'Environnement. The grant of BLUP does not exempt a promoter from any other statutory obligation, and every approved development must be implemented strictly in accordance with the approved plans and permit conditions. The promoter and the responsible professionals, including the architect and engineer, are required to ensure full compliance with the application planning guidelines, building regulation, engineering standard, environmental requirements, and construction norms governing the approved project. Any non-compliance may result in enforcement action by the competent authorities. Local authorities cannot lawfully grant permits that are contrary to statutory requirements, especially for planning, control, technical standard, or environmental safeguards. Mr. Deputy Speaker, sir, government remains committed to ensuring that development in Kalojin and even all around the island proceed in a planned, balanced, and sustainable manner. No permit is granted unless all applicable legal, planning, environmental, and technical requirements have been satisfactorily addressed.
The Honourable Third Member for Port North Rhode Island.
Je vous remercie, Monsieur le Vice-président. B896, s'il vous plaît.
Mr. Deputy Speaker, sir, with your permission, I will answer to this parliamentary question. I am informed by the National Land Transport Authority, NLTA, that with regard to the provision of school bus services for students residing in Vallée des Prêtres, Port Louis, and attending the James Bertie David State Secondary School, Bell Village, transport facilities are currently being provided along the said corridor through regular school services operated by United Bus Service Limited and other operators. These include, in particular, Route 160A, which provides a dedicated school trip to Vallée des Prêtres via Vallée Pitot. In addition, other supporting services are being operated, namely Route 115 from Plainvert via Trangbar and return via Vallée Pitot, Route 33 and 33B serving the Transportation Center and Plainvert respectively, Route 115A via Trangbar, as well as Route 51 operated by Triolet Bus Service Company Limited from Pointe-aux-Sables. Collectively, these services contribute to the overall accessibility of a school for students traveling from Vallée des Prêtres and surrounding regions. Mr. Deputy Speaker, sir, I understand that Honorable Savabadi had informed the substantive minister about this matter. They both did a site visit in the vicinity of the school. The NLTA is monitoring the situation closely and is maintaining close coordination with the school and operators to assess demand and operational conditions on an ongoing basis. Mr. Deputy Speaker, sir, should the need arise, appropriate remedial measures, including adjustments to existing services based on capacity, will be considered in consultation with stakeholders to ensure that students are adequately catered for. The NLTA has been requested to carry out a survey to that effect. I am tabling the timetable for routes 160 and 168 for the benefit of the House. Thank you, Mr. Deputy Speaker, sir.
Yes.
Je remercie le ministre pour sa réponse. Juste pour rappeler qu'au niveau de James Bertie David, il y a pas mal de requêtes qui nous sont parvenues pour qu'il y ait un ajustement par rapport au service de transport public pour les élèves atteignant cette école. Puis-je demander à l'honorable ministre de transmettre le message au niveau de la NLTA pour que le survey soit réactualisé dans un moment assez rapide, puisqu'on a les périodes d'examen qui arrivent très bientôt, si le nécessaire pourrait être fait rapidement. Merci.
Mr. Deputy Speaker, sir, the needful will be done.
The Honourable Second Member for Belrose.
Je vous remercie, Monsieur le Vice-président. B9, 8, 9.
Mr. Deputy Speaker, I wish to point out that cases of teenage pregnancy are reported to my ministry by medical social workers from all the regional hospitals throughout the island for follow-up, and cases are referred to the drop-in center by the family support services of my ministry. I wish to inform the House that since December 2003, my ministry, through a drop-in center located at Port Louis and managed by the Mauritius Family Planning and Welfare Association, works towards the rehabilitation of adolescents, teenage mothers. The objectives of the drop-in center are: A, to ensure victims' empowerment through referrals to educational and vocational institutions and other related organizations; B, to promote the concept of entertain to education activities like personality development programs and art competitions; C, to help mothers, teenagers acquire both social and life skills to overcome their traumas; D, to conduct group therapy sessions and focal group activities; and E, to ensure the rehabilitation of these teenage mothers and their reintegration into the society through networking with appropriate stakeholders. The services offered by the drop-in center are inter alia as follows: A, counseling; B, prevention through talks in the community, including schools; C, medical sessions conducted on a monthly basis for mothers and babies; D, broadcast radio programs on a fortnightly basis in Creole and Hindi; and E, recreational activities held on a quarterly basis. Mr. Deputy Speaker, sir, pregnant adolescents and teenage mothers are vulnerable. They therefore require dedicated support with regard to their emotional, psychological, social, and economic needs. Thus, whenever cases are reported at the level of family support services of my ministry, individual counseling, guidance, and psychosocial support services are also provided to them, as well as to their families. Home visits and follow-up sessions are conducted with the pregnant adolescents and teenage mothers to ensure that their best interests and rights are safeguarded and that they are living in a safe and secure environment. Mr. Deputy Speaker, my ministry also provides necessary counseling to encourage stronger family support, improve communication between parents and children, and promote responsible parenting practices. If required, the pregnant adolescents and teenage mothers are referred to the Ministry of Social Integration, Social Security, and National Solidarity for financial support. I wish to inform the House that the adolescent-friendly sexual productive health services of the Ministry of Health and Wellness are provided at primary health care level through area health centers, community health centers, mediclinics, and regional hospitals. And healthcare professionals have been sensitized on the provision of confidential, respectful, and youth-friendly services. Since 2025, my ministry has been strengthening collaboration with community organizations, NGOs, and relevant ministries' departments through the Community Child Watch Program and the District Child Protection Committee under my ministry. These two programs facilitate coordinated interventions, improve referral mechanisms, and ensure effective follow-up of cases, including teenage pregnancy cases. Furthermore, I'm informed that the AIDS unit of the Ministry of Health and Wellness implements a range of evidence-based interventions, contribution to the prevention of HIV, as well as teenage pregnancy. This unit carries out awareness sessions in secondary schools on sexual and reproductive health and HIV prevention. Mr. Deputy Speaker, sir, I'm also informed that Since January 2025, sexual education has been integrated within the school curriculum and covers topics including sexually transmitted diseases, reproductive health, gender rights, common taboos, and misconceptions. My ministry works in coordination with the Ministry of Education and Human Resources to ensure that the content is both age-appropriate and comprehensive. Particular emphasis has also been placed on boys and young men as active participants in prevention, recognizing that gender-based power imbalances and attitudes towards sexuality are key drivers of teenage pregnancy.
Yes, Honorable Martil.
Je vous remercie, Monsieur le Vice-président. Je remercie l'adjointe au Premier ministre pour sa réponse. Pourrait-elle indiquer à la Chambre si elle aurait les statistiques sur le teenage pregnancy, s'il vous plaît?
Malheureusement, non, Monsieur le Vice-président. J'inviterai l'honorable membre à venir avec une question, substantive question on that.
Je vous remercie, Monsieur le Vice-président. Would the Deputy Prime Minister inform the House what specific tailor-made measures has her ministry put in place to address the issue of teenage fatherhood? Thank you.
C'est une bonne question. Je pense que c'est une bonne proposition à laquelle on va considérer, bien sûr.
Last question for today, Honorable Juman.
899.
Mr. Speaker, sir, the National Social Inclusion Foundation, NSIF, operates under the aegis of the Social Integration Division of my ministry and is governed by its council. The aim of NSIF is to empower and improve the well-being of people living in conditions of poverty and vulnerability through impactful and sustainable stakeholder partnerships. The foundation is the central body that receives funds collected by the Mauritius Revenue Authority, MRA, in accordance with the legal provisions under Section 50L of the Income Tax Act, under the Corporate Social Responsibility, CSR provision. As per its charter, NSIF is to allocate funds to non-governmental organizations for the benefit of vulnerable groups to support programs and projects in priority areas of intervention, such as the socio-economic development as a means of poverty alleviation, educational support and training, support people with disabilities, family protection, including gender-based violence, and environment and sustainable development. Mr. Deputy Speaker, sir, with regard to Part A of the question, I am informed by NSIF that from July 2025 to April 2026, it has received a total amount of 976,058,116 rupees. As regard to Part A2 of the question, the operating costs for NSIF amounted to 162,115,132 Mauritian rupees and 52 cents, as at April 2026. Mr. Deputy Speaker, sir, with regard to Part B of the question, I'm informed that there is a well-structured funding mechanism established at the level of NSIF, whereby funds are disbursed strictly to NGOs duly registered with the foundation and based on projects received following call for proposals launched by the latter. NSIF disbursements both from funds received from the MRA and from funds invested as per its reserve and investment policy. Furthermore, I'm apprised that a 4-tier process is adopted by the NSIF for a rigorous evaluation of projects prior to the approval of fund allocation. The first stage relates to an initial screening constituting of administrative checks. Subsequently, at the second stage, a technical assessment is carried out whereby the proposals received are examined and assessed based on their relevance, effectiveness, efficiency, impact, and sustainability of proposed interventions. The third stage involved the validation of the technical assessment by the Project Management Committee. Finally, the fourth stage constitutes the approval of the project proposal and funding thereof by the Council. Mr. Deputy Speaker, sir, for this financial year, as at April 2026, I'm informed that an amount of 1,058,808,995 Mauritian rupees and 50 cents has been disbursed to 240 beneficiaries, namely NGOs and charitable homes, to implement their respective projects and programs, including their operational costs. Mr. Deputy Speaker, sir, given that the NCIF deals with public money for the benefit of the House and for the benefit of for public interest, I am tabling the full list of beneficiaries, namely the 240 NGOs and charitable institutions, and the amount of funds dispersed by NCIF to the respective entity. Okay. I'm informed it's the first time that this kind of list is deposed in the National Assembly.
Thank you. Only one question. You have time is over.
Thank you, Honourable Minister, for tabling the list. Honourable Minister, given that the NCIF is intended to support social inclusion and vulnerable groups, can you confirm whether any organization affiliated with major profitable corporate groups has benefited from NCIF funding, and how such allocation were justified in light of the foundation objectives?
I think this is a very good question. The topic is in discussion in the board of NCIF. It has been the practice in recent years under the previous government and board. This discussion is ongoing. I have my own opinion on it, and I will give my opinion to the board when the board will take a decision on this issue. It is not a correct practice for me. There is no one with acquired rights under NCIF. Every project has to be analyzed and decided on the merits of the project, not as an acquired rights. This is my step.
Time is over. Honourable members, the table has been advised that the following PQs have been withdrawn: B908, 909, 900, 904, and 901.
Motion.
Honourable Prime Minister.
Mr. Deputy Speaker, I move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10.
Seconded. The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favour say aye. Aye. Those against say no. The ayes have it.
Statement by Ministers. None. Public bills. First reading.
Mr. Deputy Speaker, I move that the supplementary appropriation 2024-2025 number 2 bill number 7 of 2026 be read the first time.
Seconded.
Public bills. Second reading.
The Honourable Minister of Foreign Affairs, Mr. Ramphal.
Thank you, Mr. the Deputy Speaker, sir. Mr. the Deputy Speaker, sir, we should be proud that after 58 years after independence, our Constitution has stood the test of time, adapting itself through various amendments without, of course, losing its core values and its core essence, that of protecting the fundamental rights of our people. Some countries have had to rewrite the constitution. Some constitutions were even revoked, but ours stood firm, resilient, protecting the rights of our people, and also making sure that the institutions that have been created in the Constitution do ensure the protection of the rights of our people. I very often, Mr. the Deputy Speaker, hear some people saying that our Constitution was imposed upon us by the British. But that's not true. In fact, as if we gave the impression that our leaders at that time were invited over a cup of coffee at Lancaster House and were handed over a copy of that constitution. But that's not true. It has to be rectified. Our constitution is the fruit of various negotiations, various sessions that occurred between the colonial powers and the Mauritian leaders. And after various sessions, various discussions, when our leaders were happy, were satisfied that constitution did contain sufficient provisions to protect the rights of our people, then it was agreed. And not even that, it did obtain the indirect approval of the people at the 1967 election. The general framework of the constitution was put to the people for vote, and they voted in favor of the coalition government led by Sir Sagor Ambrang. It was after that, then the British passed the Mauritius Independence Ordinance in the British Parliament, and then we had the 1968 Constitution. So, as I've said, Mr. the Speaker, sir, very often we hear people saying that our Constitution was handed over to us. I believe that I had to make this point very clear. It is also with pride that we can say that there have been various judicial pronouncements that have come mainly from the Privy Council on the interpretation of several sections of our Constitution that have been used as reference, as precedents in various other jurisdictions. Let me just give, especially in Commonwealth jurisdictions, let me just give a few examples. The cases like the state against Koirati, where they laid emphasis on the separation of powers between the judiciary and the executive. And this case is being used now everywhere in various jurisdictions as precedent. The case of Dom Halingam against the state, where the citizens' right to be tried within a reasonable time. The case of Dwarika and the DPP, which talks about the vital role of the media in a democracy. So all these judicial pronouncements that are now being used in various jurisdictions emanate from interpretation of our Constitution. This is why Mauritians should be proud of that Constitution. As I've said, Mr. the Deputy Speaker, sir, our Constitution has also evolved. It has evolved with time, and it adapted itself through various amendments. Today, once again, we are being called upon to consider setting up a commission to make recommendations in order to bring extensive amendments to the Constitution in order to reinforce the fundamental rights of the people and to consolidate the institutions that has been created under the Constitution. Now, the people should ask the question, why are we doing this? Why have we taken such a decision? Because little did we realize that one day there will be a tyrannical government who will rule and who will even dare to abuse people's rights. People have, sometimes I listen to people over the radio. They criticize on social media. They don't realize that 2 years back, under the MSM regime, what haven't we witnessed? They tend to forget very easily. And I'm going to remind the people, because unfortunately Mauritians, they tend to forget very easily. But it's good that we use this occasion, since we are talking about constitutional rights, fundamental rights, institutions. It's good, Mr. the Deputy Speaker, that I remind the people about what has occurred in those past 10 years. In the midst of the political campaign in November 2024, access to the social media, access to internet was suspended in complete violation of the citizens' right to information. C'est arrivé à Maurice en 2024. In April 2021, the MSM government launched a consultation paper. What to do? To amend the ICTA Act in order to create a National Digital Ethics Committee composed of political appointees who would decide, they would decide what contents they would allow on the social media. Vous imaginez ce qui s'est passé sous le MSM? Luckily, there was public outcry and they retracted from this amendment. In November 2021, sometimes I hear those, what the private radios. Do they realize in November 2021, the MSM government amended the IBA Act to reduce the duration of private radio licenses from 3 years to 1 year, avec le but in order to make private radios at the beck and call of the MSM government. They also introduced an administrative fine up to 500,000 rupees, un demi-million de roupies as administrative fine if the private radio don't follow the broadcasting guidelines. This is why it is important, as has been mentioned in the present bill, that we have to think about the introduction of new generation bills, freedom to information, freedom to technology, to digital and information rights. Mr. Deputy Speaker, sir, in December 2016, the Prime Minister has made reference to this. Would you imagine? They brought the Constitution Prosecution Bill to create a monster, a prosecution commission composed of political appointees. And you know to do what? To issue directions to the Director of Public Prosecution, which is an independent body under the Constitution, to decide who to prosecute and who not to prosecute. They even succeeded in curtailing the powers of the DPP on the decision to prosecute in corruption and money laundering cases. And they transferred that power to a political appointee, the then director of ICAC. The police force, which is supposed to be ensuring law and order in the country. We were supposed to have an independent commissioner of police in command of the police force, but the commissioner of police at that time was taking direction from the kitchen. The police force was being operated from SunTrust. This was what was happening 2 years back. People have forgotten how the SST was being used to traumatize political opponents, or even those who dared to criticize the policies of government. There were cover-up inquiries. What haven't we read in the report of the magistrate of the Boca Tribunal in the Kisnan case? Cover-up in murder cases. I listened to some police officers, even my bodyguards. They are complaining about promotion. Do they realize, for the first time in the history of this country, under the MSM government, promotions were given to police officers close to politicians, and the routine order was not publicized, was not published. In opacity. They even didn't know who was being promoted, who was not. This is how promotion was given under the MSM government. An accelerated promotion to some of them. So, even the judiciary was not spared. Would you believe this, Mr. Deputy Speaker, sir? Even the judiciary. You remember after the verdict in the Medport case by the two magistrates of the Intermediate Court, finding the then Prime Minister guilty, Pramin Jagnat, his father, late Shadurut Jagnat, who was then the Prime Minister, you know what he said about the magistrates? And I will quote in Creole, allow me, Mr. Deputy. He said, "In un ban magistrat nouveau, pénal expérience, je donne banzisement back." And the son was not better. When Bruno Loret was given bail, the Prime Minister, Pramin Jagnat, he said, "Jamais me fin trouve un jugement d'un magistrat aussi bancal que ça. L'ien incompétent, il pas comprendre même qu'il a fait la loi." This is how heads of states under the previous MSM government were treating the judiciary. And in this August Assembly, Mr. Deputy Speaker, sir, in this August Assembly, supposed to be the temple of democracy, what have we witnessed? The most atrocious ruling ever being handed down at every session of this Assembly by the former Speaker. And the former DPM was right, I remember. He was saying that when we come to power, we have to delete all these rulings from hands on. He was right. And there was no decorum at all. And parliamentary words were being allowed. And even the then Speaker was using parliamentary words. You know, Mr. the Deputy Speaker, sir, just to give an example how this House was being managed, I decided to go and make a relevé to see how many times, on how many occasions, MPs were either ordered out, named, or suspended. Do you know how many times?
Every session.
Every session. 123 fois. On 123 occasions. At one time, all the opposition members were ordered out. And for the first time in history of this country, the budget, the Committee of Supply was voted in one day.
Yeah.
Without any question put.
At 1 a.m.
Would you imagine this? This happened under the MSM regime? In this very house, supposed to be the temple of democracy? And sometimes when you hear people talking outside, criticizing us, they've forgotten what has happened just 2 years back. Mr. Mr. Deputy Speaker, sir, the Bank of Mauritius, another example. The Bank of Mauritius became a money printing machine under the MSM government. The Bank of Mauritius, which was supposed to be an independent body looking after monetary policy, was being used to cover for the fiscal deficit of government. This is what the Bank of Mauritius was doing. They had printed, the Prime Minister said it the other day, they have printed 181.5 billion of rupees. 1.8 billion of rupees printed. This is why it is important, as has been mentioned in the bill, that we have a senior officials appointments committee to make recommendations on the appointment of heads of some public institutions. Municipal elections have not been postponed once, not twice, on 3 occasions. En 3 occasions, les citadins, they have been prevented to vote for their representatives at municipal election. This is why we have to come up with provisions so that never again municipal elections, local government elections are postponed. And also we need to have a constitutional division of the Supreme Court, because cases involving breach of constitutional rights need to be treated with urgency. Look what has happened about the election petitions that we had entered in 2019 after the elections. It took the judiciary, I'm not criticizing, for several reasons. It took them 5 years, 1 whole mandate of the previous government to deliver judgment in the election petition. 1 whole mandate, and you see, because of that, people unfortunately lose trust in the system. And this is why on the day of election, the last election, people started taking control of government vehicles, of electoral vehicles, carrying ballot papers to ensure that elections are done fair and free. This is what happened when you delay to give justice. This is why it is important that when people feel that their constitutional rights is being breached, they have to be given justice with urgency. They have to be treated with urgency. So even the Prime Minister made mention about this, using covert surveillance for eavesdropping on citizens' life. So Mr. Deputy Speaker, sir, I'm not going to be long. So the government at that time,
1 minute.
1 minute, became so untrustworthy when it comes to protection of the fundamental rights of people, that the citizens, on the day of election, they decided to use their own pen. They sanctioned the previous government and gave us the mandate to protect their fundamental rights and consolidate democracy and institution. And this is what we are doing today with the introduction of this bill in Parliament. Thank you, Mr. Deputy.
Honorable Jitan.
Mr. Deputy Speaker, sir, I speak today in support of the Constitutional Review Commission Bill. As a citizen of this country, one may ask, why do we need to review our Constitution? After all, our Constitution, as my colleague has just said, has served us well for 58 years now. It has provided stability, safeguarded democracy, protected fundamental rights, and helped transform Mauritius from a small island with no resources into one of Africa's most successful countries. But Mr. Deputy Speaker, sir, the true strength of a constitution is not that it never changes. The true strength of a constitution is its ability to remain relevant in a changing world. It is not merely a legal document. A constitution is like a compass for a nation. It does not determine every step we take, but it provides the direction by which we navigate moments of uncertainty, of disagreement, and of change. Through Vision 2050, we are asking ourselves what kind of economy we wish to build, what opportunities we wish to create, and what future we wish to leave to our children. Yet no national journey can succeed if we neglect the compass that guides it. And just as a navigator periodically checks whether the compass remains true during changing conditions, nations too must periodically reflect on whether their constitutional arrangements remain adapted to the realities of their time. The purpose of constitutional review is not to change our destination. It is to ensure that future generations can continue the journey with confidence, stability, and trust. Mr. Deputy Speaker, sir, we are modernizing our economy. We are modernizing our infrastructure. We are modernizing our technology. And so it is only legitimate that we also reflect on whether aspects of our constitutional framework should also be modernized for the challenges of the 21st century. In fact, this is what the people of the country expect of us as a government. And history teaches us a very important lesson. Prosperous nations are not built merely by exceptional governments. Prosperous nations are built by exceptional institutions. And as my colleague just said, institutions that are referred in the bill, like the judiciary, like the DPP, like the Appointment Commission. Governments come and go, political parties rise and fall, but strong institutions endure. Indeed, the true test of a nation's maturity is the quality of the institutions it leaves to the next generation, and it provides the strong local democratic fabric. So the purpose of constitutional review is to protect tomorrow's citizens. As the Minister responsible for economic planning, I have the privilege of leading work on Vision 2050. Vision 2050 asks a fundamental question. What kind of Mauritius do we wish to leave for the future generations? What sort of economy do we want? What sort of society do we want? What opportunities do we want our children and grandchildren to inherit? But there is another question that is equally important. What sort of institutions do we want them to inherit? Vision 2050 is about designing the future of our economy that is socially inclusive and embedded into sustainability. The Constitutional Review Commission will look into designing the future of our democracy, and one cannot succeed without the other. Economic development without strong institutions is fragile. The Senior Official Appointment Committee is one such initiative that will create good governance in public administration. Democracy without effective institutions is vulnerable, and the establishment of a constitutional court will reinforce that. National prosperity without institutional trust is unsustainable, and the two journeys must therefore proceed hand in hand. Mr. Deputy Speaker, sir, as I said, Mauritius is quite unique in many ways. Our greatest resources are not oil reserve, not minerals, but the resilience and the talent of our people. And more importantly, it is the trust that our people place in our institutional fabric and democracies endure where institutions are trusted. So that is why constitutional review is not merely a legal exercise. Mr. Deputy Speaker, sir, there is another reason why this exercise is important. Constitutions are designed to manage disagreements. When everyone agrees, institutions are rarely tested. The real test comes when there is disagreement. A good constitution provides rules, safeguards, and institutions that allow differences to be resolved peacefully, fairly, and democratically. This is one of the greatest achievements of constitutional democracy, not the absence of disagreement. And the bill, Mr. Deputy Speaker, sir, provides a fabric to enhance the resolution of any such differences. Mr. Deputy Speaker, sir, every generation faces its unique challenges. The generation that negotiated independence confronted poverty, uncertainty, and questions about whether Mauritius could survive as a nation. Today, we face different challenges. Artificial intelligence, cybersecurity, climate change, demographic change, geopolitical uncertainty, rapid technological disruption. The world of 2026 is not the world of 1968. And the world of 2050 will be even more different. And so this raises a profound question. What obligations do we owe to Mauritians who are not yet born? The answer, Mr. Deputy Speaker, sir, is simple. We owe them institutions that are at least as strong as the one we inherited. We owe them a democracy that is at least as resilient as the one that our forefathers built. We owe them a constitutional framework capable of protecting their freedom long after we have left public life. This is the essence of intergenerational justice. We are temporary custodians of an inheritance. Our responsibility is not merely to preserve it, our responsibility is to improve it before passing on. Mr. Deputy Speaker, sir, the strongest societies are not those that never question themselves. The strongest societies are those that possess the confidence to examine themselves honestly. As an island state, we must be agile. We must be more forward-looking. We must be more willing to prepare for tomorrow rather than merely react to yesterday. And as we stand today in this fast-changing world, constitutional renewal is a necessity. The Constitutional Review Commission Bill is therefore not about rewriting our history. It is about preparing our future. It is not about abandoning our foundations. It is about strengthening them. And so I return to the work of Vision 2050. Vision 2050 challenges us to think beyond electoral cycles, beyond annual budgets, beyond immediate pressures, beyond the politics of the day. The Constitutional Review requires exactly the same mindset. It requires us to think not as politicians, but as custodians, not as occupants of office, but as stewards of national inheritance. Mr. Deputy Speaker, sir, every generation inherits a nation it did not build. Every generation benefits from its institution it did not design. The question before us today is therefore both simple and profound. Will we leave those institutions stronger than we found them? Will we leave our democracy more resilient than we inherited it? Will we leave our future generation better equipped to face the challenges of their time? If the answer to those questions is yes, then this bill deserves our support. because constitutions are not monuments of the past, they are bridges to the future. And it is our responsibility collectively and courageously to ensure that bridge remains strong for generations to come. And our colleague just stated about the challenges of modern world. The challenges confronting democracies across the world today that our founders could scarcely have imagined when our constitution was drafted. Information traveled slowly. News was verified before it was published. Public debate took place in media, in town hall, in newspapers, in parliaments. Citizens could disagree, but there was usually a common set of facts upon which that disagreement was based. Today we live in a fundamentally different world. Information travels instantly. Rumors travel faster than facts. Outrage often travels further than reason. And algorithms increasingly reward what is sensational rather than what is true. Technology has given every citizen a voice, and that is a remarkable democratic achievement. But it has also created new challenges. Across the world, we are witnessing the rise of populism, polarization, and division. Too often, public debate is reduced to slogans rather than solutions. The challenge of our generation is therefore not simply to preserve democratic institutions, it is also to preserve democratic culture and trust in facts, not slogans. Mr. Deputy Speaker, sir, this is why constitutional reflection is more important today than at any time in recent history. The architects of our Constitution designed the pillars of our democracy, judiciary, the DPP, local democracy, which were capable of managing the challenges of their age. Our responsibility today is to ensure that our constitutional fabric remains resilient in an age of artificial intelligence, digital misinformation, global connectivity, unprecedented technological change, climate change, etc. For if the 20th century taught us that democracy must be protected from authoritarianism, the 21st century teaches us that democracy must also be protected by strengthening fundamental rights relating to the above. It is a national challenge, and it is a challenge that demands foresight, wisdom, and courage from all of us. So let me conclude with a quote, a famous quote from Abraham Lincoln. The best way to predict your future is to create it. I thank you, Mr. Deputy Speaker, sir.
Thank you, Honourable Minister. I suspend the sitting for half an hour.